Hey guys, what's up? So let's resume our class and now we will discuss fundamental rights. Very important. It has been asked quite a lot of times in various examinations conducted by the Union Public Service Commission, that is UPSC. So this is one of the most important aspect of our study in the introduction of polity. Okay, these classes are for introduction only. Okay, so now let's continue part 3, that is fundamental rights. Let's begin our discussion with why fundamental rights. As we know, our country is a democracy, a republican democracy. Okay, so in a democracy, the cornerstone is fundamental rights. Cornerstone of democracy is fundamental rights. But if you go back, it, it is actually the rule of law. And rule of law gives rise to fundamental rights. As in rule of law, it is also known as lex rex. Law is the king of kings. So anybody cannot exercise arbitrary power. Authoritarian rule should not be there. And to curb that authoritarian rule, there must be some written fundamental rights in the constitution itself, which grants you protection from the state action. Okay. Later we will study that not only the states, certain rights are also available against individual actions. Okay. Now we should also see or discuss from where the fundamental rights have been taken from. Because in our Indian constitution, during our study of the preamble, we have discussed there are various features which have been inspired from the other constitutions. Okay, so most of you, I think, have already aware about this Bill of Rights. This is from the US Constitution. Okay, this everybody knows. Second is Nehru Report of 1928. This report contained around 19 fundamental rights, or specifically 19 fundamental rights. Many of these have been directly incorporated in our constitution. Okay, this also inspired this part 3 of our constitution. And I would like to let you know, in USA or in UK, there is no emergency provisions. So fundamental rights there cannot be suspended. But here we have the emergency provisions, and from where it has been taken, the Weimar Constitution of Germany. Okay, these questions might not be asked, but this is just for your knowledge. Constitution of Germany, and specifically Article 48. Okay, this Article 48 enables the president to rule by decree. You know of ordinances, like here in India, president passes ordinance. There it is known as decree, similar thing. And this article was used by a very famous historical figure. You might know his name, that is Adolf Hitler, to undermine the democracy and to rule as a dictator. Okay, this is the history, like why we need fundamental rights, from where our fundamental rights have been taken inspiration from, and the emergency provisions are taken from this, the Weimar Constitution of Germany. Okay, let's see from whom it gives us protection. We will first discuss the state, and later certain articles also grant specific protection against individuals. Okay, so if a question arises, is fundamental rights available against the state only? No, it is against individual action also, but in certain fundamental rights only. Let's begin with article number 12. Okay, this is the definition of state. In this part, unless the context otherwise requires, the state includes the government and parliament of India, and the government and the legislature of each of the states, and all local or other authorities within the territory of India or under the control of government of India. I'll tell you the most important nuance here. this other authorities. See, state includes government and parliament of the union, government and legislature of the states, and also remember of the UTs also, union territories, and local bodies. You know the local bodies, urban local bodies, rural local bodies. Like in panchayat we have a three-tier system, and in urban local bodies we have municipalities and municipal corporations for a city having population more than 1 million, that is 10 lakh. Okay, so all that, you know, my consideration over here is this other authorities. Always remember that a private entity or a corporation can also be termed as state by the Supreme Court or High Court during investigation if that is under the control of Government of India. I'll explain more. This is not this only, but okay, under the control of Government of India, but also an entity or a corporation if it performs a public function. That means a person, a public function is something like which the government has to perform. If a state like gives its function to other corporation, then that corporation automatically comes under the definition of state, and we will know this test using that. There is a important case, Ajay Hasia case, I think 1983, in which Supreme Court laid down the test instrumentality of state. How they will test it? In simple words, if a government body, that is an authority which is a state, entrusts its function to some other private corporation, so that will also be a state. Or corporations such as LIC, ONGC, or bodies which are heavily controlled and partially or maybe fully owned by the government, those also come under the definition of state. So remember this case, guys, Ajay Hasia case. I think the full name is Ajay Hasia versus, you will Google it. Okay. Also a very important fact. This is not a right. Article 12 is not a right. It is a definition. There's a difference. See, Article 12 is defining whom you can sue if your fundamental rights are encroached. In specific, in most of the fundamental rights, the action is available against the state. So we are now concerned with the action against the state. So if anyone's fundamental rights are taken away or encroached, whom they will sue? In the court, the state. And this particular article defines the state. It is not a right, it is a definition of the state. Okay, a very minute difference. Let's see Article 13. All laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. Okay. The state shall not make any law which takes away or abases the rights conferred by this part, and any law made in contravention of this clause shall be, to the extent of contravention, be void. This second one is known as doctrine of severability, and the first one is known as doctrine of eclipse. Let me explain both. Okay, the second one, okay, and the first one is doctrine of eclipse. You know what is an eclipse? Like covering certain things up to cast a shadow. In the first one, all laws in the territory of India which have been in force shall be void until amended the constitution by the parliament shall be void. It is like covering up. Second one is like the new laws which shall be passed will be passed by the parliament or any state legislature. The state shall not make any law. It also consists of the executive also. So remember this. Here it is written as the state. So automatically by the definition of Article 12, executive also is part of state. Okay, shall not make any law, and if it makes, that will be void to the extent of such inconsistency. A technical term, let me make it very clear and easy to understand for you. Like I have, if I am an executive, I pass an order containing five different clauses, okay, like A, B, C, D and E. There are five different clauses in this bill, and A is perfectly fine, B is perfectly fine, C is fine, but D and E are violating fundamental rights of certain section of society or any individual. Okay, so what the judiciary will do, or what will happen actually, is only D and E will be struck down. They will be void. We can also say that null and void or struck down. Okay, but the other parts can continue. This is known as the doctrine of severability. Sorry for my pronunciation. Sometimes it happens. Okay. Also, it gives a definition what law means. Okay. Law not only means something passed by the parliament or the state legislature or an order given by an executive power, but actually it consists of orders, bylaws, customs, and any like decree which have a force of law. Okay, so even in customs passed by some authority that may not directly come under the definition of state, but it affects a large number of individuals, and that has the decree of law or the force of law, then that also comes under the definition of this law. Okay, not only legislature but every other authority who is competent enough to pass a law. This is the most important thing. Forget about that. That is easy to understand. I have told you. We will discuss this more. Okay. Nothing in this article shall apply to any amendment of this constitution made under the Article 368. This is directly saying law does not mean Constitutional Amendment Act. Is it okay? Is it right? Think for yourself. Is Constitutional Amendment Act not a law? Yes, it is a law. So why it is specifically been excluded from here? This was done by the parliament to escape the judicial review. See this number over here, 1. Okay, let's see when it was inserted. Inserted by the Constitution 24th Amendment Act 1971. So if a question arises whether in the definition of Article 13 law includes Constitutional Amendment Act or not. Earlier I used to think that Constitutional Amendment Act also is a law, but specifically now make yourself very clear that it is not. Okay, and this has been also confirmed from by me and my friends from a professor of law. Okay, so Article 368 Constitutional Amendment Act is not a law under the definition of Article 13. And let's discuss judicial review, because judicial review is kind of deriving its power from here. Never write it as like this key Article 13 specifically grants the power of judicial review, but judicial review derives its power from here only. Also, as the Supreme Court and High Court are court of law, court of record, sorry, court of record, they inherently have judicial review power. Okay, let's see right to equality. If I am unable to explain certain things, I will upload some more videos, because this is a trial class and this isn't just an introduction. We are going through the trying to grasp the overview of the Constitution of India. Okay, and I will try to make more comprehensive videos, which will all be absolutely free, uploaded on this channel, and there will be more subjects added later. Okay, let's see right to equality. Article 14. The state shall not deny to any person equality before law or the equal protection of the laws within the territory of India. Very beautiful law and very much to discuss over here. There are many nuances of this particular thing. Equality before the law. Remember this, law, singular form. Okay, laws, plural form. Why there is a difference? Why distinction over here? It means whenever in constitution, always remember, whenever in an any important legal document, and this is one of the most important legal document, so if a word has been used, it has a specific meaning. So here it is written as singular and here it is written as plural. They convey a different meaning. Here we are talking about the Constitution of India, okay, or the law of the land. When we are talking about laws, here we are talking of statutory laws. What is a statutory law? A law passed by a legislative body. Who are the legislative bodies in India? The parliament and the state legislatures, or the legislature of a UT. Okay, a very minute distinction between the two is this conveys the meaning of constitution or the law of the land. This talks about the statutory laws. Particularly, first one says that any person equality before the law or equal protection of the laws. First one is guaranteeing the rule of law. Okay, protection of laws within the territory of India. This is giving power of judicial review also. The first one has been taken from the Constitution of United Kingdom, UK. There's a difference between UK, England, and British. Okay, I'll explain some other day. The Constitution of UK, this is rule of law, protection of the laws. This has been taken or inspired from Constitution of USA. If the legislature within the country passes any law, that should not be discriminatory in nature. That should be equal for all. But let me clear all kinds of myth here. Right to equality is not absolute. Okay, right to equality is not for everybody. What I mean by this, equals will be treated as equals, unequals will be treated as unequals. There is a very like vague definition of this in the starting phase of any aspirants like journey to prepare for civil services or any other exam. I also used to think that right to equality means everybody is equal. No, there shall be and should be a reasonable classification. Everybody is not treated equally because everybody has a different circumstances. So equals will be treated equally, unequals unequally. I'll explain. First is reasonable classification. Let's say a person who is 20 years of age comes and hits you on the head. Okay, will he be committing a crime if you are hurt? Yes. But a little boy of age 5 years comes and hits you on your head. Will you give them both the same punishment? I don't think so. You will say that your reasoning will be here that this fellow is kind of unaware of his actions and he might not be intending to hurt you, but this person is absolutely well aware he might be your enemy, that let's just hit this guy. Okay, so as a student of like CSE only, let's say, you are able to use your discretion and say they should not be treated equally. In the same manner, the constitution or the statutory laws will never treat everybody equally. Why? Because they are coming from different circumstances, different instances. So remember this thing: reasonable classification. Who will decide classification is reasonable and on what grounds? It has to be done by the judiciary. Okay, so always remember, this does not mean everybody is equal. Article 14 does not mean everybody is equal. It means equals are equal. It will be applicable where two persons of similar circumstances, instances, and intentions are treated equally. Okay, it might now not make sense right now, but when you will think about it slowly and slowly, you will understand every bit of it. And even in further lectures, I will try to explain all the things more clearly. Okay, let's see Article 15. Most of you have read all these, so discuss I should discuss the things which are missed by most of the people. See, important point is this: only. It means the government or the state can discriminate between people when the grounds are different from these. And also remember, like, the state can also make situations where they can say certain of these grounds combined with other ground. Okay, remember this word: only of religion, race, caste, sex, place of birth, or any of them. It means if these are made in combination, any one of them or any combination, then the state cannot discriminate against any individual, but they can discriminate against the individuals based on like educational qualification or place of residence. There's a difference between place of birth and place of residence. So, like, educational qualification, let's just discuss first. You will not go to an engineer to get your bone fixed. You will not go to an engineer and say, I have a ear problem. So, make sense? So, how can you expect a person not having professional competence would be eligible for an opportunity in a public office or any post or government education system? So, it means government can discriminate between people if they are lacking in certain educational qualification. This sounds reasonable. Why this? Place of residence, you can guess. There are certain regions in India where the population do not want encroachment by the outsiders, specifically the hilly regions and the mountainous regions. People do not like people like disturbing their sanctity or like natural harmony. This is specifically not for that only. I'm just giving an example. Place of residence can be made a discrimination point in many places. Like, if government wants certain jobs, barring the top jobs, should be taken by only the residents of that state, this is only to enable the residents of that state to be able to have the opportunity to work there. Okay, so remember, in 15, remember this: discrimination on other grounds is possible. If grounds are these or any of these, it is not possible. There is a power cut. We will resume shortly.